Give me a second, Mr. Villanueva. Okay, Judge, we're live.
Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for November 30th, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, would you call our next case, please?
Yes, Judge. Cause number 2020-0D04363. Cause number 2020-0D06556. State of Texas versus Rafael Villanueva. Announcement of counsel, please.
Good afternoon, Judge. Josh Avila for the state. Stage ready?
John Williams, the advisory counsel for Mr. Villanueva. We're ready, Your Honor.
Mr.
Mr. Villanueva for the defense. Ready.
And sir, we are scheduled today for, I believe, a judges conference. Have you all made any headway since we were last here?
Insofar as a bond judge or a plea agreement?
Are we set for a bond hearing? I only have us down for a judges conference. Am I looking
Well,
at?
Judge, at the last hearing, we had a bond hearing, and you said if there was anything else, we could bring it in front of you at this point. So I know Mr.
Okay.
Villanueva would like to address you on that matter.
Okay, sure. My apologies, Mr. Villanueva. I know we had addressed the bond last time. So I only had it down for a judges conference, but if you're ready to proceed, Mr. Avila?
I'm ready, Judge.
Okay.
I noticed that there was a bond hearing in this case. I didn't know if it was a continuation or not.
Okay, Mr. Villanueva, you may proceed.
Hey, I would just like to request that bond be reduced in the case for terroristic threat. And I know that I think a couple of PR bonds were issued the following week after we had the bond hearing, and I received those on, I believe it was the 16th of November. I would just ask if right now at this point I'm unable to make the bond at what it is set. I think the bond is set $10,000 with a $1,000 PR bond. I would request that the bond be reduced to 5,000 unsecured surety, and I think the remaining amount would to be set at a PR bond. And that's because at this point I have secured some funds for the bond from my friends and family in the total amount of $500, and that's what I would be able to post if the bond is granted. And I think that's basically all I have right now as far as for the continuation of what we went off of last time.
Okay. Mr. Avila, are you prepared to go forward on that? Do you have enough, I guess, in front of you? I know you're new in a sense, and so I don't know how much of a background you have in these particular cases, but are you prepared to go on the bond? I'd very much like to know if there's any opposition or concerns in terms of a complainant, anything like that.
Judge, I am ready for the bond hearing. The only thing I don't know is I know there was a bond hearing before, and you had, I believe you had reduced the bond before. I don't know if we were waiting for a change of circumstances or to see how much he had accumulated to see if that was enough. I don't know. Otherwise, Judge, I'm ready to go forward in any way.
Mr. Villanueva and Mr. Williams, if you'll help me on this, this is what my memory is. And I apologize because today they're very capable, but I do have some substitutes in today in terms of our clerk. And I know our clerk is really good about looking things up. Mr. Hinojos is here, but I don't know that he was here at the last hearing. My recollection was, and this is without me going through Odyssey, is that the case 6556, which is the terroristic threat, was actually at a $10,000 bond, cash surety bond, and I did not reduce it. What I did do was add a PR component because in the second case, I think I made that a straight PR bond. Am I not mistaken on that? Because it was a criminal mischief and there was some discussion about it being really a misdemeanor, that kind of discussion. And so the purpose last time, hold on, Mr. Villanueva, was that I made the PR conditions consistent between the two cases. In other words, adding the PR component to the terroristic threat. But at that time, based on the information that was presented to the court, I felt that the $10,000 bond was a sufficient and appropriate bond for that case. So that's what I recall. Mr. Villanueva or Mr. Williams, if you recall anything differently, so you know, Mr. Avila, that's kind of where it was last.
What I think everything is correct on what you're stating, Judge. The only difference that I might have is according to the jail records, the current jail records show that the criminal mischief is set for a $1,000 bond and an additional PR bond component for an additional $1,000.
Okay, let me look that one up. Mr. Nojas, is that what you see as well?
Yes, Your Honor. Just so I can clarify it, for the 4363 case, that one has a $1,000 cash surety and a $1,000 PR bond.
Okay, that sounds right. Right, so we did a 1,000 because that's what it was, because it was a misdemeanor-ish criminal mischief. I think that's what we discussed last time with the $1,000 PR component, and then adding the 1,000 on the other case. And so with that, Mr. Avila, what is the position on bond reduction?
Right, Judge. In fact, I even if the court was under the impression that we were going to give a PR bond on that criminal mischief, I did see those issues. I would have no issues, but the problem is on the other one, Judge. I know you're aware that this case was transferred. It was actually transferred from the 171st, Judge, because the court there decided to revoke his PR bond because he picked up a criminal mischief, and then it turns out that the court was receiving threatening messages. Did Mr. Villanueva inform the court how much he can afford, if anything?
I think I just heard $500.
So a $5,000 cash surety bond?
Right, with the remaining balance being factored in with the PR bond.
And Judge, one thing I also saw was the fact that this case just recently came back from competency. I know there's a history going back and forth.
I just need to know if you're opposed to a reduction.
I have no issue, Judge. I have no issue. My only issue is I don't know if 5,000 would be appropriate enough. I was gonna say $7,000 or $8,000. And just so the court is aware, I know there's a probation rec in this case. That's the only reason why I have no problem with him being released in some sort of bond. I would like to see how he will do out on PR bond. And even if he's to be released on PR bond, Judge, I will ask for any safety measures like Takumi or EHN, anything that was part of his competency regime.
Okay. All righty. Anything else, Mr. Villanueva? Anything? Let me ask. I don't see on my PR bond here anything reference. Oh, yes, there is. Never mind. There is the mental health. Mr. Villanueva, I don't need you to go into details, but are you receiving any treatment in jail?
No, no, Judge. I am not receiving any treatment. I think I have objected to the ruling on the transfer to the inpatient mental health care facility and the findings of the doctor, Steve Rubenezer, only because I'm not dealing with any type of anxiety issues or depressive issues or any type of mental health related issues. And so me coming into this facility back in December 3rd of 2021, I never requested any kind of a medication or any mental health care related type of issues. However, given the concerns from the ADA, I would not be opposed to following up with any kind of, how can I put this? Maybe additional screenings for mental health if the pure bond is granted. But I do feel like I'm fine all around on the mental health side. There is just one additional issue, and that is the PR bond or the case on the criminal mischief. I know it is set at 1,000 and an additional 1,000 non-secured surety and 1,000 PR. Given that the state would probably have difficulty proving their case, as was discussed on the previous hearing, and given that the maximum statutory limits for the offense of a Class B misdemeanor, which is what it's looking like, would run out here pretty soon within the next few days, I would ask that the criminal mischief be made a full PR bond, only because we would probably ask for the case to either be dismissed or be fully PR bond in any way in a few days.
Mr. Avila?
And that's true, Judge. On the criminal mischief, I have no issue with it being a full PR bond. The issue is that the terroristic threat of a judge.
Okay. Okay, but you're telling me you're not opposed to some reduction on the threat?
I have no issue, Judge, with a reduction. My only issue is that I do think that $5,000 is too low.
All righty, and then let me see. Let me go back and look at something. Okay, it looks like we have. I don't know if I've asked you this, Mr. Villanueva, because it has been some time. But what is your living situation? You have a place to go to if you get out, that type of thing. You have family. What's going on?
Right. I have a place that I can go when I'm released. If I am released, if I bond out, my uncle said that I could stay with him in the meantime while I get myself up on my feet. I will be working in my previous job, which I was doing concrete, and last year in 2020, it hit a really hard economic slump in about May. So from about May to the time of my arrest in December, I was limited to a few jobs and very limited on income. But the way that they tell me that right now the work is really picked up, I would be working full time. It shouldn't take me very long to get back up on my feet. And
so let me stop you real quick, Mr. Villanueva. What's the address, your uncle's address?
His address is 400. Well, no, it's 447 Shoots Avenue.
What was that street?
447 Shoots Drive. And that's in apartment 258.
Okay. So anything else, Mr. Avila?
Judge, I don't know, were you given a report of how he did on PR bond before by any chance?
So I believe we received it from the 171st. If you're talking about one of the regular ones that I guess I get from Mr. Gonzalez, no, from
Okay.
PR recently I have not, because we received, Mr. Villanueva has never been out since he's been here. I would really have to search for a PR report.
It seems like he was out on PR bond on this case back in July of 2020. The incident with the judge happened in October, so he was out around 3 or 4 months before he was arrested. I honestly, in full candor with the court, Judge, I don't think reporting is his issue. His issue is picking up new cases. He picked up a criminal trespass and then a terrorist threat on a judge.
Okay. Let me see. Chris, can you contact PR Bond, please, and ask them to send me what, I don't even know if there was a PR component before. Yeah, there had to have been. A PR report on Mr. Villanueva. I gotta think it's on the old case, but just shoot him both case numbers and see if he can email me quickly. Josh Gonzalez or Jacob Garcia, if somebody over there in PR Bond.
Okay, Judge.
Okay. All right. Well, I'm gonna have to wait for that just for a second, gentlemen. So if you'll please stand by. As soon as I get the report, we can go back and finish up that bond hearing. Okay?
Okay, thank you.
Good, Judge.
All righty. If you'll just mute, please, Mr. Villanueva.
Okay.
Please, since that's all we have on for now at downtown, let's just scoot over to
The annex, Judge? Yes,
Yes,
Judge, we could take care of Cortez if you'd like.
let's do that.
Page 7. Annex, if we can get Luis Cortez, please. Luis Cortez.
Yes, Your Honor.
Good afternoon, Mr. Cortez. Is your turn? Oh, Mr. Morales is there. Okay. Good afternoon. Can you hear me okay?
Yes, ma'am.
Thank you. How are you doing today?
I'm doing good. Just another day, a good day. Had a good Thanksgiving. It's my mom's birthday on that day. It was all right.
Let's get started, shall we?
Yes, Judge. Cause number 2020-0D01582. Cause number 2020-0D00058. And cause number 2019-0D03226. State of Texas versus Luis Alberto Cortez. Announcement of council, please.
Josh Avila for the state, Your Honor. State ready.
And Rafael Morales, on behalf of Mr. Cortez, Judge, we're ready as well.
Okay, we are scheduled today for a final hearing plea deadline. Mr. Cortez is appearing from the jail annex. Mr. Avila, what is the rec on Mr. Cortez?
Judge, so the last note I have in this case is that I think someone lowered the rec in this case, either to 3 or 2 TDC. They sent back plea paperwork in June. I'm not too sure what happened. I don't know if there's a potential for an agreement. I will honor that rec.
Okay, so I heard 2 different numbers, Mr. Morales.
Judge, I love that too, but that had never actually come out by previous ADAs. I would never sandbag Mr. Avila. He knows that.
Okay.
The number that they were kind of stuck on your predecessors was 3.5.
3.
Mr. Cortez is very, very close to being able to parole in absentia. I mean, he's coming up on that
So
3 years.
a 3-year sentence will give him a parole eligibility. If he's willing to plead to 2 TDC, I'm okay with that.
Well, are you saying 2 or are you saying 3? Because you just said 2 again. Don't get us excited.
2. No, well, no, I said that on the 3 part, if the distinction between you and me is 3 or 2, I'm okay with doing 2 because either way he's parole eligible. For the most part, he's almost going to be done with his sentence. So I have no issue with 2 if he's willing to plea.
All right.
Got even better, Judge. And the sticking point, and I continued to search for authority or evidence from his recent treatment at the psych center, something there that would suggest that he was not competent to go forward with his plea. And I was looking for some authority that would guide me in terms of that February competent report where he was found competent and his subsequent hospitalization at the psych center that would suggest to me that I should not do it. I did not find any authority telling me that I shouldn't. We've got the most recent competency evaluation, unfortunately, was a while ago, but it does say that he's competent. All my in-person meetings with him over the last couple of weeks have suggested to my untrained eye that he is competent. I will have one final opportunity to evaluate him when I go over the plea paperwork with him. And then I think this thing pleads, Judge, and hopefully I've covered myself so there aren't any issues for me later.
So here's the thing, you're set for trial on Thursday.
Judge, if we need to go because we can't get the plea done because I had legitimate concerns about his competency, that's fine too, Judge.
Well,
whatever you want, Judge.
If that's the case, Judge, then we probably, if there's concerns with competency, we can't go to trial either.
No,
Well,
no, no, no. Well,
and-
here's, and again, I apologize, Mr. Avila, because you're stepping into, we've been over this over and over again.
Oh,
Since
okay.
we got him back from the psych center. And I've yet to hear something specific other than this. There's always the possibility that he is not competent, but at the same time, there has been no indication, Mr. Morales, nothing specific or substantive or detailed from you and your client that says to me, we have reason to think now he is not competent, because as he is, we have had now multiple hearings where he has come in and is engaged in a little bit of conversation with regard to his case. I'm not saying that's equivalent to a doctor evaluating him
Of
for
course.
competency, but I haven't heard yet that there is an issue, and I don't have that concern right now, to be quite honest. And I see your client jumping over there, and I understand if there is a concern, if there's, he seems anxious to plea. He said it last time. Now he's got a better offer, and I know that can in and of itself be the reason. I get that. But as we've sat here, hearing after hearing, I am still not seeing the specific reason you are asking to have him evaluated again, because I don't see it.
And Judge, I think my position at this point, I mean, you certainly understand it, and I'm just trying to cover myself, Judge, because he's got a number of issues, and I just worry. I just worry, Judge. I'm telling you, we've requested that he be evaluated. I'm telling you, I've not seen anything in his recent behavior that would suggest that he is not competent. I did search for authority to help guide me. We still have not gotten his records back from Mr. Lopez at the psych center. I would love to see those, but I didn't get any indication from them that they felt that he was not competent. I was just going
Is
belts and
Mr.
suspenders
Lopez
approach.
the same gentleman that was here at that hearing? Was that the
Yeah.
same individual? Yes?
That is
He
correct.
came in here and said he's competent.
He's not a actual mental health professional. He's, I guess, the case manager type person over there.
I understand, but you're telling me that you're waiting for records from him when he actually came in there and told us.
And Judge, from the criminal defense lawyer perspective, I'd love to see something on paper, but they didn't have anything. But they didn't have anything saying that he was incompetent either. They just had something. They had records that were showing the mental health issues that he was suffering from, Judge.
I need you, because there is a new rec now. We are going to take a quick break off the record, and we are going to put Mr. Morales and Mr. Cortez in a breakout room.
Judge, I know he wants to take it. It's not an issue. I mean, that we're good, Judge.
Yeah.
So Judge, can I suggest something, Mr. Morales?
Sure.
Can we just do the plea paperwork, test it out, and let's start the plea process? I know the judge, if the judge sees a concern, I'm pretty sure the judge will stop it. Right,
Yeah.
Judge?
Judge, I'm gonna cooperate with Rafael Morales told me with the EHN after I'm out, because that's the best thing to get my medication, but I'll be all right.
So I think at this point, are you asking then for a plea? If you're asking for a plea, then I'm going to set you for a plea, and I'm asking your attorney. It's just why I wanted to give you a breakout room, but if you all want to just address it now, it's up to you.
But Judge, he does want to plea, and that's always been the case, Judge. So,
Okay. And we are setting that then for December 14th at 3 p.m.
sounds like a winner. Josh, thank you.
You
Thank you.
need to send
Yes,
over the
sir.
paperwork. Mr. Cortez, I just in terms of the timing, the court schedule is really, really full, which is why we're going 2 weeks down the road, but we will have you set at that time. It has to be at that time. Unless, Mr. Morales, are you requesting an in-person plea?
We can do either, Judge. I don't mind.
Let's do an in-person plea on that day,
On what day, Judge?
on December 14th. We'll do it at 11 a.m. So we'll need to make the request to have Mr. Cortez brought over.
Yes, Judge, I got that.
$11 a.m., Judge, is what you said?
Mm-hmm. That'll give us time to do our morning docket. All right. That's what it's going to be. Set it for 11 a.m. on December 14th.
Sounds great.
Okay,
Sounds great.
see you then.
Thank you so much.
Take care, Mr. Cortez.
Thank you, Judge.
All right, who's next, Tree? I haven't received anything
Sorry,
from.
Ortega
PR,
on
so-
page 9.
Okay. Go ahead.
Annex, if we can get Agustin Ortega, please. Agustin Ortega.
Thanks, Chris.
Should I just want to let you know hi Judge, we're out here. We're not logged in. So
I saw you guys. Thank you.
Yes, Ms. Ryan. Be right with you.
No, I just wasn't sure. No rush.
And Judge, before we continue, can I get just, I think I have an idea of what the rec is. Is it a misdemeanor family violence case?
So I don't have any plea papers on Mr. Ortega.
Oh, excuse me then.
Yeah. So we were set for a plea today. Go ahead, Chewy. I mean, I'm assuming this is the one Chewy and I discussed before. I didn't have any plea papers on it.
Yes, Judge. It's cause number 2021-000-1744, State of Texas versus Agustin Ortega. Announcement of council, please.
Josh Avila for the state, Your Honor. State's ready.
Carlos on behalf of Mr. Ortega, ready to proceed, Your Honor.
And Mr. Ortega is appearing from the jail annex. We were scheduled for a plea today. I have indicated here that I did not receive any plea papers. Mr. Avila, do you know if those have been circulated?
Judge, I believe they were sent out. I'm not too sure, but I will defer. Mr. Eric Hernandez is here, if he may. He seems to have sent out the plea paperwork, if he may.
Sure. Mr. Hernandez?
Mr. Hernandez, are you there? Eric
So Judge, I
Hernandez?
can tell you that we did receive the plea papers. We did do a call with a jail call. So it would have been up to the jail to then forward them to the court. And that's when we set it for a plea.
We looked earlier this morning for plea papers and I don't have any plea papers. So I don't know how we track those down. Mr. Lozano, if you have the copy, no, because then it would have to be signed through the jail call. I don't know what to do. You all, we did not receive them. So.
Judge, I do know that my client, I've already gone over them actually twice with him. He does want to go forward with it. I can forward the plea papers to the jail right now. And
we are, my apologies to your client, but we are beyond double booked and literally for like the next 2 weeks. So the soonest I can bring him in on my jail time is December 14th.
well, it doesn't sound like a question.
It isn't. I mean, here's what I can tell you. But this is basically your footwork. I don't have a problem if you are able to secure the plea paperwork, the signed paperwork. If you can want to see if another district judge will do the plea for you in their jail slot, that might expedite things. It's just we are beyond filled.
That's fair honest.
Okay.
Yeah,
So
just
I will put you.
normally in your court, we don't get a plea setting unless there are plea papers.
Right.
So I had no idea that was even an issue.
Yeah, I don't know how that happened, but I don't have any plea papers. So I will put you down for December 14th at 3. What I'm telling you, Mr. Lozano, is if you're able to track them down and get that squared away and get another judge who will do the plea for you, I'm happy to let you do that, by all means.
We'll
I'm
change
assuming,
it.
I'm assuming he's gonna be released, right? Is that what it is, or is it, what's the,
No, Judge, it's the parole's waiting for this information. And so,
Here at the annex office, we have the papers. If you would like, we can forward them right
Oh, wow.
okay, send them on over.
They're on their way around.
Let me see, are they,
Annex, if you could forward them to my email address, please.
Judge,
I see them, I see them. All righty,
Judge, I sent you a chat. Good afternoon.
I have it, Carla, thank you.
Yes, ma'am.
Mr. Lozano, they've just been sent to me.
thank you, Judge.
Mr. Ortega, just give me 1 second, please. $168 days, okay. All right. Okay, so it's reducing to a Class A assault, 168 days?
Yes, Judge. I got the plea paperwork and I already know everything. Yes.
Okay, all right, let's get started. My apologies, Mr. Lozano and Mr. Ortega. All right, go ahead, Chuy. Oh, did we already announce? We already did. So now we found the plea papers. Mr. Ortega. We are scheduled for a plea today, so thankfully we don't have to reschedule it. I'm going to be asking you questions regarding your plea, so I need to swear you in. If you would please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Sir, would you state your name for the record, please?
Agustin Ortega Jr.
Sir, I'm going to need you to speak up just a little bit and you can put your hand down.
Agustin Ortega Jr.
Thank you very much. Sir, as I mentioned, there are now documents regarding your plea. The first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Sir, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within the document?
Yes, ma'am.
Mr. Lozano, have you had more than 10 days to prepare a defense in this case?
We have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I believe that he has.
Mr. Ortega, are you satisfied with your attorney's representation of you?
Absolutely.
Mr. Lozano, you have any reason to believe that your client is not presently competent to enter a plea?
None at all, Your Honor.
Mr. Ortega, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today, sir. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso?
El Paso, Texas?
Yes, ma'am.
Okay. So the charge against you originally indicted was an assault, family violence with a previous conviction. However, through negotiations, I understand you're pleading to the lesser included offense of assault causing bodily injury, which is a Class A misdemeanor. To that lesser included charge, sir, what is your plea, guilty or not guilty?
Guilty?
Are you making your plea freely and voluntarily?
Yes, ma'am.
I'll find you're making your plea freely and voluntarily. Mr. Avila, would you summarize the evidence, please?
Yes, Your Honor. Had the state proceeded to trial on the lesser included offense in this case, state would have proven beyond reasonable doubt through competent witness and evidence that on or about the 24th day of April of 2021 in El Paso County, Texas, Agustin Ortega did then and there intentionally, knowingly, or recklessly cause bodily injury to Wendy Gomez by pushing Wendy Gomez about the face with the hand of the defendant. And Your Honor, just to clarify for the record and for the court on the plea agreement, we're not asking for a family violence case, a family violence finding, excuse me. At this point, Your Honor, State moves to admit Exhibit Number 1 as a plea agreement, Exhibit Number 2 as a 39.14, and the summary of the evidence for the record.
Any objection? Without objection, State's Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
The plea agreement, Your Honor, is for Mr. Ortega to plea on the lesser included Class A misdemeanor and be sentenced to 168 days in jail, that he be given credit for any time that he has served and no fine be assessed.
Mr. Lozano, is that your understanding?
It is, Your Honor.
And Mr. Ortega, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Ortega, do you recall reviewing the trial court certification and signing that document?
Yes, ma'am.
It was signed by your attorney and it was signed by me as well. So on your plea of guilty and the evidence introduced at this time, I will accept your plea and find that the evidence substantiates your guilt. I will find you guilty of the lesser included offense of assault causing bodily injury, and I will sentence you according to the plea agreement to 168 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Mr. Avila or Mr. Lozano?
But nothing from the state, Your Honor.
Your Honor, only if the court would consider giving him credit toward any cost that he would have associated with this case.
Absolutely.
Thank you, Your Honor. Nothing
All
further.
right. Thank you, and apologies for the confusion. Thank you, Mr. Ortega.
Thank you.
Good luck to you, sir. All righty.
May I be excused, Your Honor?
Yes, sir.
Thank
Thank you.
Annex, if we can get David Ibarra.
Oh my gosh. Perfect. Mr. Ibarra? Go ahead. Mr. Ibarra, are we ready?
Yes.
Okay, Judge. It's cause number 2021-020-1353. State of Texas versus David Ibarra. Announcement of council, please.
Josh Avila for the state, Your Honor. State ready.
Good afternoon, Judge Sam Flores. On behalf of Mr. Ibarra, we're also ready.
We're set for a bond hearing. I'm still showing public defender. Did you sub in, Mr. Flores?
Yes, I did, Judge.
Okay. All right. Then your client is appearing from the jail annex. You may proceed on your bond hearing.
Thank you, Judge. Judge, on behalf of my client, he's 32 years old. Prior to being, he turned himself in when he learned that he had a warrant out for his arrest through the PR department. I guess he was notified, so he self-surrendered on or about the 25th of October. So he's been in jail for a little bit over a month now. He was residing with his mother, Ms. Marisela Perez, and his younger brother at 3431 Bisbee. This would be the address if the court was to allow him to be out on bond. He'd be going back to mom's house. He has two younger children, Judge. I can't remember the age. I spoke to him today at the annex, but he has a little girl, a little boy. He's still legally married. He's separated. He's under a child support order, which he's been in compliance up until the date of his arrest. He was working as a warehouse clerk. He's unsure if the warehouse where he was working at will bring him back and give him employment, but certainly that's something he would like to explore and do again. Judge, we're asking the court to consider a 5,000 split bond, 2,500 surety, 2,500 PR. The only person at the house working right now is his mom or his mother, Ms. Marisela Perez, and she works part-time for Bien Vivir, but she's not making that much income. She was able to get some funds from family members so that they can hire my office to help them out in this case. One thing that I spoke with my client about today was if he had missed any court hearings in the past, and his indication was that he had never missed a court hearing, and this is the only offense holding him currently, Judge. So we're respectfully asking for that request of the court.
Mr. Avila?
Your Honor, so the reason he's in jail is because he had a PR bond. Well, before he was on a $9,000 cash surety bond with a $1,000 PR bond. The reason he got revoked, Judge, is because starting on, so what was it, September the 19th of this year, he actually got very, very high ratings on the machine, Judge. I don't think I've seen, I know this is going to sound exaggerated, Judge, but I don't think I've seen that high of a reading on the machine. He had a 0.24 on September the 19th. He had a point, you know, 0.03. The next day, later on, he blew where was it? He blew a 0.24 on September the 26th. And then there was another occasion where he blew a 0.24 or 0.18. This happened within the span of September 19 all the way up to the last reading that the PR bond had, which was October the 18th. The next day being when they got the warrant from the court.
Mm-hmm.
Judge, it should also be noted that this is a second DWI, right? I feel like there's a risk that Mr. Ibarra will continue drinking here.
Mm-hmm.
And I'm not too sure how secure we are, not only that he's not drinking, but that he's also not driving.
Some of the issues I saw, I recall, Mr. Ibarra, and you're right, Mr. Flores, it wasn't an issue of him appearing, it's him not having the monitor and not being compliant with the monitor. And I think there was a concern, although I'm not sure I've followed the full email chain here, about his operating a motor vehicle. I don't know if he has a valid driver's license or not, but he was not to operate a motor vehicle. And so I don't have the full set, I guess, of emails, because this was an ongoing issue with your client. What is his current bond?
It's 101,000.
A little bit over 100,000, Judge.
Mm-hmm. Does he, he's been in jail for a while, so what is the status of the monitor?
I'm not too sure, Judge.
Okay. So for now, anything else, Mr. Avila?
No, Judge, just the high readings were just a concern for me.
Right. So for now, it is high. The bond is high, but it's high for a reason. I don't have a problem, though, reducing it somewhat. What I'm going to tell you, Mr. Flores, is it's not going to be what your client needs. And let me tell you how we can possibly go lower. It's going to be that monitor be set up so that if we get to a bond that he can be released on, that he's immediately on the monitor. So for now, the bond is going to be 20,000 cash surety, 5,000 PR. He must have the monitor, not operate a motor vehicle without a driver's license, and valid insurance. So he may drive if he's got a driver's license and the monitor. And then curfew, no alcohol, all those standard conditions that we have on our DWI. And it has to be the portable monitor unit on him with the GPS and daily reporting requirements. Mr. Flores, I know that might not get you where you need to be right now in terms of your client being able to bond out. So my suggestion to you is, if you want to come back on a bond hearing to get that lowered again, I need to know that upon his release, he has that monitor ready to go.
Understood, Judge.
All righty. Thank you very much.
Thank you, Your Honor.
Okay. Who's next, Tree?
Hey, Judge Monares.
Okay.
Annex, if we can get Francisco Monares, please.
Your Honor, my apologies. I just wanted to clarify on the defendant of how many times you wanted him to test per day. Was it just going to be one time?
No, I think it's four times on that portable. I think that he had to have been either 3 or 4. So we'll get.
I'll go ahead and put 4, Your Honor.
Thank you. Oh, there it is. All righty, go ahead.
Yes, Judge. Cause number 2016-020-2790, State of Texas versus Francisco Monares. Announcement of counsel, please.
Josh Avila for the state, Your Honor. State ready.
Richard Roman on behalf of Mr. Monares, ready to proceed.
And
Liana,
oh, sorry.
sorry, Judge. Liana Gandara, adult probation.
Thank you. And Mr. Monades is appearing from the jail annex. We are scheduled for a probation status hearing. Is this one where we had a new case outstanding? Mr.
Yes.
Avila? Yeah.
There is a case outstanding, Judge. The case got created in the beginning of November. I do not see any status updates on it. I do see that it got assigned to a prosecutor, but it hasn't been accepted. I just today I got the opportunity to kind of follow up on that and see if we can get that case indicted. Let me see, Judge, because I don't believe that it was a blood draw. I believe it was a blow, so it shouldn't be an issue to get it indicted. Let me just double check, Judge, if I can get a couple of seconds here.
Sure.
No, right, it was a blow.
Yeah, I think I remember that from.
Right.
Things.
Judge, can I ask, what was the previous status? Did Brian say that he was going to follow up? I want to know, I guess I want to get an idea of how many times you've asked us to see if we could get this case indicted.
Let's see. So we've had a couple of hearings with Mr. Roman, and I think that was the issue at all times. Am I right on that, Mr. Roman? Let me see events.
Yeah, you're exactly right.
Oh my goodness.
We've been here for a minute. And so let's see. We had a status conference. The last time we were here was October 26th. We had, October 12th, motion to reconsider. That was on the bond, or I'm sorry, on the motion to recall. And the motion to recall was originally heard in August 24th. So we're looking at,
Do we have, because I know we already have the case, Judge, and it got assigned to an attorney. We just need that attorney to review it, accept it, and then we need to get into the queue of the
grand jury.
Grand jury. I do want to ask Mr. Roman a favor, if we can. It just expedites this entire process, and that is if he can file a motion for an examining trial.
Your Honor, as you say, we've been here a couple of times. The last time we were here, you indicated that you were going to require Mr. Monades to give you some jail time, but my county's done about 50 days so far. Last time I checked, this case is still in pre-file. It's a blow case. I don't understand what the delay is in the DA's office, but we've done everything that you've asked. He's given you 50 days. He's registered himself in jail in an addiction class. We want very bad into rehab. This is just, more delay. We'd like to ask for time served, get him released so that he can get on down the road and get his rehab going.
Well,
and Judge, just so I can get
hold on. Believe me, I hear you, Mr. Roman, but that does not abdicate you from doing what you need to do for your client either. And what Mr. Avila is suggesting is, I don't have any doubt. This is where I am. I am going to reset the probation status hearing for 2 weeks. I am confident Mr. Avila is going to turn around and run this case that has been outstanding into the queue for grand jury. And assuming we get an indictment, I think we might have that case. You still, though, I don't know if you all, are you representing him on the new one? I thought you were.
Yes, I am.
Okay. Well, I mean, this case has been, if memory serves, the date of offense on that DWI was July. Am I right on that?
Yes, ma'am.
That is correct, Your Honor. Yes, and I will. Yes.
So a motion for examining trial would have been appropriate months ago.
Yes, it would have been, Your Honor, had Your Honor not explicitly explained to the DA's office on your instruction that you wanted the case taken to the grand jury and indicted a month ago. That was your instruction, Mr. Herrera.
I understand, but they're going to do what they're going to do with their cases. What a defense attorney can do is certainly file a motion for examining trial. I'll tell you this, though, you will get a probation status hearing in 2 weeks, December 14th.
Well, if I'd have known that, Your Honor, I would have sidestepped your admonition to the DA's office and done exactly as you're suggesting, but I will do that now.
Good luck. Thank you.
Thank you.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Who's next, Tree?
Thank you.
Okay, Annex, if we can get Benjamin Duarte. Benjamin Duarte, please.
Yes, sir.
Thanks.
Benjamin Duarte.
Okay, okay. Give me 1 second, Mr. Duarte. I just received the downtown, Mr. Villanueva, if you're there, Chewy, let's go, and let
Yes,
me
ma'am.
just forward this if I can. Mr. Villanueva, I don't have a way to send you this case summary report. May I send it just to Mr. Williams? I'm gonna send it to Mr. Avila as well, because he's the one that asked for it.
Okay, thanks, Martin.
Mr. Williams, do you have an email? And can you
Yeah.
unmute? Can you unmute, please?
You're muted.
Sorry, JL,
Uh-huh.
like Leo Williams, 1119 at yahoo.com, Judge.
Yeah.
JL Williams, 1119 at yahoo.com.
Okay, it's on its way. I haven't even looked at it. So let's get back on the record. In cause number 2020, and my apologies, Ms. Lerma, just something popped up real quick. We'll get right back to you.
No worries, Judge.
2020 0D04363, State of Texas versus Rafael Villanueva. I know there's another cause number. This is the PR report I received. Did you both receive it, Mr. Williams and Mr. Avila?
I did, Your Honor.
Okay, so.
I have not yet, Judge.
Oh, man. Okay.
Let me see if it went to spam. I know for some reason the county hates
Yeah.
So I didn't, let's see if it's coming.
I'll start reading it.
It's kind of short.
Yeah, it's kind of short. Let me just get back over there. Okay, Mr. Arena, he remains in custody as of today. Notice of violation was submitted to the 171st prior to the case being transferred. It was the rearrest for the criminal trespass. Prior to his rearrest, was reporting as instructed, no other issues to report. So there we go.
That's right.
Okay. So then back on the bond, anything about that report? Change anything for you, Mr. Avila?
No, Judge. The only concern, obviously, is just rearrest, and he reports as indicated.
Okay.
In other words, you're asking, Judge, if the $5,000 bond would be enough?
You're telling me no. I heard you say that before.
Right.
And
I
so
said
you
no.
were saying about 7,000 or 8,000. That's what you're.
That's correct. Yes,
Okay.
Judge.
So, and you had no objection to a full PR bond on the criminal mischief.
Absolutely, Judge. No, I haven't. I'm okay with a PR bond on that criminal mischief due to the evidentiary issues.
Okay. So let me just make sure I pull up. So I'm going to go ahead and grant your request, Mr. Villanueva. Let me just make sure I get everything spelled out correctly as I can. So the request, however, is not going to be as low as you wanted. What it will be in cause number ending 6556. I will lower the cash surety portion to $7,500. It will continue to have a $1,000 PR component to that on that case with the same conditions as we have had previously, which does include a mental health angle. I'm not referring you to, I'm not hearing any, specific screening that's been done in terms of Takumi, but you must comply with any mental health treatment that you were receiving either before you were put in jail or during. Not possess any weapons or ammo, report weekly to PR bond, not commit any new offenses. You are to reside with your uncle, and you may not, at that place that you described, that apartment, but you may not change that place of residence without court permission. So I understand sometimes, our living situations can need to change. What you are going to be required to do, though, is notify PR bond that if your uncle says you need to move and you have someplace else to go, you need to let PR bond know so they can let me know and we give you permission. Understand, Mr. Villanueva? I don't want to lose track of you, okay?
Yes, Judge.
Okay, and then you are not to leave El Paso County without permission. You will have a curfew from 10 p.m. to 6 a.m. unless you are working or going to school. You're to have no contact with any of the complainants in either of these cases. That means no verbal contact, text, messages, direct contact, and you may not come within 200 feet of any alleged complainants. If there is a particular, if there's a particular residence on the criminal mischief or anything like that, I'm not sure. I'm not sure if there's anything like that, but that restriction will be there as well.
Right, Judge. And Judge, just so we can kind of get to the practical aspects of it, the complaining witness in that the terroristic threat case is the judge in the 171st. How would you want to enforce that? Do you want to have for him not to, not to step on the 6th floor, or how will that work?
I will be handling everything remotely, right?
Okay.
I mean, that's how I see us going for now. So the distance restriction is what it is. For my purposes, the 6th floor is the 1st floor. Do you understand? And so, Mr. Williams, if you will discuss with your client what that restriction, or not with your client, if you would answer any questions that Mr. Villanueva might have, we have this benefit, Mr. Villanueva, right now of having this remote process. You are going to be required, obviously, to show up for all of the hearings. And you're going to do that in the manner we're doing it right now, but you're going to have to do that from your own device, whether that's a phone or you can call in. You have the means to do that?
Yes, I do. I have my brother has a computer at his home that I could use if that's what it's going to take.
Okay. Alrighty. And so again, no illegal drug or alcohol, not leave the county, no criminal. Okay. I think everything's there. It is going to be, Mr. Villanueva, I know you've seen the PR bond order that was previously, it's the same conditions, it's just new amounts. So we're doing the what did I say? Hi.
7,500?
7,500 with the 1,000. On the criminal mischief, it's going to be a straight $1,000 PR bond. Okay.
Okay. Thank you, Judge. Thank you.
Alrighty. Wait, you know our next hearing date?
I have December 7th for a status hearing at 3 p.m.
I am showing, and someone please correct me if I'm wrong on this. I am showing January 18th, 2022.
Okay.
Mr.
Pre-trial.
I'm writing that down, January 18th, 2022. Okay, at 3 p.m.?
That is going to have to be at 10 a.m. now because you're no longer on the jail docket.
Okay.
Well, I'm assuming you're no longer on the jail docket.
I think that it's very, very likely that I probably within the next couple of weeks should make that happen with additional funds from my friends and family.
Chris, for my purposes, we just need to add a 10 a.m. setting to the January 18th date. So,
okay, Judge, so I'll change it from 3. I'll change it from.
We need 2 settings. So we need one at 10 and leave the one at 3. Because if for some reason Mr. Villanueva is still in jail,
we have both.
We have it.
You got it.
Thank you. Thank you, gentlemen.
Thank you, Judge.
Thank you, Judge. Can we excuse?
Yes.
Thank you, John. Bye.
Thank you. Bye.
Annex, if we can get Duarte, please, Benjamin Duarte.
My apologies, Mr. Duarte. Let's get started.
Yes, Judge. It's cause number 2018-0D04081, State of Texas versus Benjamin F. Duarte. Announcement to council, please.
Josh Avila for the state, Your Honor. State's ready.
Veronica Teresa Lerma, Your Honor, on behalf of Mr. Duarte, we are ready.
And Mr. excuse me, Mr. Duarte is appearing from the jail annex. We are scheduled today for both the status conference and bond hearing. Can we just touch briefly on the status before we get on the bond hearing, Ms. Lerma?
Yes.
Can you give me, this is one where I think we've been coming back and forth. Can you give me a quick update?
Yes, Judge, last time, or are you asking me, Judge, or probation?
Yes, no, I was asking you because I feel like we ultimately ended up at a bond hearing probably because we were at some kind of impasse.
Yes, Judge, the offer has been 2 years TDC. My client has declined that on this revocation. As of November 9th, when I last checked, he has a total of 191 days credit plus about 124 hours of trustee credit. And so he has declined the 2 years TDC I think last time he addressed the court, and I addressed the court that he's asking the court for another opportunity to get on probation. He was asking the court perhaps to consider some rehabilitative component to modify his probation to those terms. And so we went ahead and set the bond hearing at that time because he does not have a bond, and we're at an impasse with respect to the state's offer and my client's declining the offer.
Okay, okay. All righty. And so we can go ahead and proceed on your bond hearing. I remember now. Thank you.
Just briefly, Judge, I'll proffer Mr. Duarte is in jail. He's been in jail now for about 3 months, I believe. I think maybe 4 months. This is a revocation. There's been no bond set. His previous underlying offenses, he was given deferred adjudication. And my understanding from what I understand is that this is his first series of violations, and he has no criminal history other than what he has before the court. He is a U.S. citizen. He has family ties here in El Paso, Texas. And because it's been about a month and a half, Judge, I'd just like for him to provide the address where he would be residing to the court since I last spoke to him, and he could have that information updated to the court. We're asking the court consider, because I am appointed to represent him, he is indigent, to consider a personal recognizance bond, or in the event that it does not want to grant that, some combination with a low bond so that he may be able to make bond if he's able to.
All right, Mr. Avila.
Your Honor, so I noticed that Mr. Duarte pled back in 2019. I know he pled to 5 years deferred, I believe. He was arrested once on February 2020, and then he got rearrested on this most recent motion to revoke. I believe the motion indicates that he tested positive for amphetamines, which I'm assuming it's either, barbiturates or methamphetamine. I don't know if probation has exhausted all kinds of help, or if he's a flight risk. I do know he failed to report when he was testing positive, but I know he was picked up about 2 or 3 months afterwards.
Right. And I do have the updated summary, Ms. Pineda, now. So he is entitled to a bond. His bond is going to be $50,000. Going back to the status conference, honestly, Ms. Lerma, I think my memory is telling me some things about where we were on this case, where I was on this case before. I'm looking at the current case summary from probation, and their recommendation is that he go to residential treatment. Please remind me, is your client amenable to that?
Yes, Judge, that's something that he's been asking for. He believes that his problems can be addressed in a rehabilitative nature as opposed to a punitive nature.
When does he term, Ms. Carla?
Have him judge until May 29, 2024.
All right. In terms of the status, Avila, you have any input on that?
Judge, what treatment has he received?
He's gone to BHRTC. He's come out. I am going to read the case summary. BHRTC from April to October 2020, modified to aftercare, and he began outpatient substance abuse. He was compliant until December 2020 when he begins to test positive for meth. Using meth and tested positive on dates listed above, VN submitted in January of 21. He was upgraded to intensive outpatient treatment. He was unable to stop using and stopped attending his group and individuals. CSO tried to regain supervision. However, he did not continue his outpatient treatment and was discharged on June 21, 2021. Notified defendant that of the bench warrant. However, he refused to turn himself in at the probation officer's request. He failed to submit any of the UAs for the month of February, March, April, May, June, July. Last contact was on April 2021, and after that date, he would no longer answer phone calls.
I'm guessing the next step, Judge, is safety. Excuse me, was that me?
Yes.
Okay. I'm guessing the next step is safety, Judge.
Rashad will be available.
Ms. Lerma, I have never been on, well, I have not been on that track. If he wants to take safety, please go over what, I don't know what we would have, if we have to do anything, any type of screening, but please explore that option with him. He has his bond now. We have the revo set for 12/7. If you can get us a response before then, that's great. I can tell you because of the court scheduling, we may need to push that back 1 week, okay?
Okay, and if Judge, if he does agree to the safe P, I can let Mr. Avila know and he can prepare the paperwork for me.
Well, it will just be mods. So
Mods,
we
right.
will just inform probation and then he'll be modified to safety on the wait list.
So if we hear from you before the 7th, we'll go that route. If not, just know that that 7th date will be pushed back to the 14th.
Judge, is there any way that I can be put in a breakout room with my client in this session, or is that not possible?
I'm gonna have to ask you to wait, Ms. Lerma. We've had so many hiccups right now. We have so many still pending. If you'd like to wait, I'm happy to accommodate you at the end.
No worries, Judge. I'll go ahead and set up a phone conversation with Mr. Duarte.
Okay, thank you so much.
Thank you.
Okay, who's next, Tree?
Judge Philip Mills on page 9. Annex, if we could get Mills, please.
Yes, sir.
Are you handling this, Mr. Avila?
Judge, I don't see Ms. Aban and Ms. Michelle Hill. I do remember I read the case. I thought I was handling it, but they handled the one this morning. I can do the one right now unless they show up.
Okay. So, alrighty, so we'll take it from there. Give me 1 second. All right, go ahead, Tree.
Yes, Judge. Cause number 2021-020-2641, State of Texas versus Philip Daniel Mills. Announcement of council, please.
Josh Avila for the state, Your Honor. State ready.
Marcelo Rivera and Edith Bayan on behalf of Mr. Mills, Your Honor. Defense is ready as well.
Good afternoon, and we are scheduled, I believe, for both an arraignment and a judges conference today. Mr. Mills, this is Judge Perez. Can you hear me okay?
Yes, ma'am.
Okay, perfect. And I can hear you just fine. I didn't know how the audio would be. We don't usually have too many people standing in front of us from there. But with that said, we are scheduled for an arraignment. Mr. Rivera, you all have a copy of the indictment.
That's correct, Your Honor. We do, and I have reviewed this with Mr. Mills prior to today, and we do waive the reading of it today.
Okay. So at this time, Mr. Mills, I'm going to go ahead and although your attorney's indicating we're going to waive the reading of the indictment, I do want to get your plea entered for purposes of the arraignment. So, sir, would you please raise your right hand? Sir, do you swear or affirm that any testimony you provide today will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down, and would you state your full name for the record?
Philip Daniel Mills.
And as you reviewed that indictment, that document that your attorney was referencing right now, do you see your name stated on that document?
Yes.
Is it spelled correctly?
Yes, ma'am.
And Mr. Mills, what is your date of birth?
December 31st, 1980.
Okay. With respect to that particular indictment, as we're not going to read it, there are 4 counts there. Counts 1 and 2 charge you with capital felonies. I'm sorry, a capital murder as to count 1 and as to count 2, the range of punishment there, of course, being life or a potential death sentence. In count 3 and count 4, you are charged with arson causing bodily injury or death. That has a range of punishment. That is a first-degree felony, range of punishment 5 to 99 years or life in prison and a fine not to exceed $10,000. As to all 4 of those counts, do you wish to enter a plea of guilty or not guilty?
Not guilty, Your Honor.
And that is to as to all 4 counts, correct, Mr. Mills?
As to for all 4 counts, not guilty.
Thank you very much. And as indicated, Mr. Rivera, you are waiving reading of the indictment. Is there anything further with respect to the arraignment that you would like to address right now?
Your Honor, just for the record, I'd like to make it clear, since Mr. Mills is appearing virtually, but Mr. Rivera and myself are present with him in the courtroom at the annex for the arraignment.
Thank you for that clarification, Ms. Bayan. I failed to mention that. Yes, both defense attorneys and Mr. Mills are appearing remotely, but in person from the jail annex. I did want to inform the parties at this time that I think part of the preliminary motion that we had this morning did bring to mind, I guess, a housekeeping matter, if you want to call it that, for the court. I have entered a protective order regarding publicity and speaking about this case with the public, which I think was part of the defense concern as well in their motion. So it was filed shortly before we started our hearing this afternoon. So you should see that come up in Odyssey. The other matter I want to just briefly address now is the scheduling. Well, I see Ms. Hill is here. Are you here on this case, Ms. Hill? Are you?
Yes, Your Honor. I apologize for being late.
No worries.
I'm at a meeting at the police department. Your Honor, I'm covering it temporarily. I'm not sure who will be permanently assigned to that particular court, but as of now, yes, I'm covering, and I have been in communication with Ms. Bayan.
Okay, and so you all, the attorneys, have seen the initial order of court setting, which set out the timetable, puts us at a trial setting in May. Our next setting, I have concerns about that. I just want to put that out there in terms of how realistic that is. It is a timetable that I think the court kind of uses as a standard timetable for all cases. I don't think that's a good fit. However, I want your input. The trial schedule will stay the same for now. We have our next setting on January 6th. Whoever is handling this case, I need you all to confer with one another if you all have an idea of a more realistic timetable for trial, and to include deadlines, something that's consistent with what the court does, with our 2801s, things of that nature, but one where we are not going to be spinning our wheels, and especially with unforeseeable circumstances with COVID, how we get this scheduled properly so we're not moving things unnecessarily. Okay?
Thank you, Your Honor. And I believe defense and defense counsel, and in my conversations with Ms. Hill, we do agree with the court with regard to the settings we already have. Ms. Hill and I have had some initial discussions, but I guess it is a little too soon to really know what's going to be coming up. But hopefully in the next couple of weeks, we'll be able to settle in on something a little more concrete as best as we can.
The best scenario for me, I know you all will work on it, would be if, by January 6th, if you have a good idea, literally bring me a slate of dates. If you have that, I will work with you on it. I just, in reviewing the case for today and looking at that schedule and knowing how difficult it probably is going to continue to be to schedule cases, I'd like to make sure I reserve you all and plan ahead of time. Okay.
Thank you, Judge.
Thank you, Your Honor.
Anything else?
Thank you, Your Honor. Nothing further on behalf of the state, Your Honor.
Nothing to the state, Your Honor.
Appreciate your help today. Thank you very much.
Thank you.
Goodbye.
And
All
if we can get Andrade, David Andrade, please.
Hi, Miss Martine. All right, is that Mr. Andrade?
Yes.
Okay,
Yes, Your Honor.
go ahead, Chief.
Yes, Judge. It's cause number 2021-020-2385. Cause number 2021-020-2386. State of Texas versus David Andrade. Announcement of council, please.
Josh Avila for the state, Your Honor. State ready.
Julia Martin on behalf of Mr. Andrade, ready to proceed, Your Honor.
We're scheduled for bond hearings. Miss Martine, your client is appearing from the jail annex. You may proceed.
Your Honor, for the record, Mr. Andrade has 2 misdemeanors pending. I have explained to him that if the court were to grant a reduction of his bond to straight PR bond, we would have to approach Judge Anshondo on those 2 misdemeanors. One is a criminal mischief and the other one is a possession of a controlled substance. My client, Mr. Andrade, is suffering from extreme high blood pressure at the jail, and that he believes is being caused by the fact that his wife, who has a broken hip, is at home where their 11-year-old grandson is taking care of her. He tells me that he would do whatever is required of him if he were released on PR bond. The family is extremely indigent. They're even having problems meeting the rent.
I'm losing you, Miss Martin. I heard meeting the rent.
Yes, the family is having problems making the rent. My understanding that the rent has been very low at $190 a month. So I mean, they have had custody of the grandchild since the grandchild was 4 months old. We're requesting that the court review this case and grant him PR bond on this charge, Your Honor. And again, I'd like to reiterate that he is going to be living at home with his wife and his grandchild, and he is willing to do whatever is required of him in order to be released on PR bond.
All right, Mr. Avila.
Your Honor, so I'm trying to see what the bonds are. It seems like the bond on the DWI is $30,000, and then the possession has a $1,000 bond, and then the misdemeanors also have bonds on them.
Right,
Correct.
and that 30,000, I believe, is a split 25,000 cash surety, 5,000 PR.
Okay. And I think what happened, Judge, was when he picked up this DWI, it was presented as a non-arrest. And then he got actually arrested when officers were dispatched to a criminal mischief, and then he picked up a possession charge. Judge, just for clarification, from what I can see on the rap sheet, this is not a true third. However, the DWI, the oldest DWIs, they date all the way back to 1988. And I know recently he had a DWI third that got downgraded to a DWI second, pretty sure because we couldn't prove the old DWIs. So for purposes of convictions that we can prove, this is a true third, correct?
So how many DWIs do we have?
I have 4 total DWIs. 3 prior DWIs, and then this is a 4th.
Okay.
But the 1988 one, I don't think we can prove, Judge. So this is probably a true 4th, a true third in sense of convictions. Your Honor, so the DWI, it involved an accident, a motor vehicle accident, where there are allegations that he hit a vehicle, right? And then after a DWI investigation, he blew a .2, where is it? 0.214 and 0.216, and then he picks up a possession, Judge. I think the possession charge has an appropriate bond at 1,000. I wouldn't have any problem reducing the DWI third, just not to a full PR bond.
Oh, yeah.
I would be okay with something between, well, let's say $10,000 or $15,000.
Mhm. Yeah. Anything else?
That would be all, Judge.
Ms. Martin? I don't know that I can get as far as you need me to get. I'll be very honest. I think the bond is appropriate. The only, you know, I just think the bond is appropriate. And so your request for the bond reduction is denied.
Thank you, Your Honor.
Thank you. All right, who's next, Chuy?
Edgar Gutierrez. Annex, if we can get Edgar Gutierrez, please.
Yes, sir.
No. Is that Mr. Gutierrez? Is that yours, Julia? Yes?
Yes.
Okay, go ahead, Chuy.
Yes, Judge. Cause number 2020-020-5514, State of Texas versus Edgar Gutierrez. Announcement, council, please.
Josh Avila for the state, Your Honor. State ready.
Julia Martin on behalf of Mr. Gutierrez, ready to proceed, Your Honor.
And Mr. Gutierrez is appearing from the jail annex. We're set for bond hearings as well. Ms. Martin, you may proceed.
Your Honor, my client Edgar Gutierrez is a resident of this whole region. He does reside at, I believe it's La Union, New Mexico. I believe he would be residing there if he were to be released on PR bond. He would be living with his mother, Lucilla, at 1001 Grant Street. I had it up, but I think it's at La Union, New Mexico. My client tells me that in the past he has washed semi trucks and he would be seeking employment as to that. At this time, he does not have any funds to post bond, and his family, I have contacted them and they have no money as well, Your Honor. So we're requesting a PR bond on this.
Okay, Mr. Avila?
Your Honor, the just for clarification, the alleged item taken in this case was a vehicle. It was returned, and the value of it was alleged at exactly $2,500. I'll be okay with a $2,500 cash surety bond with a PR bond. Which is the value of the vehicle?
What's the, oh, we have a pretty good criminal history.
Right, correct.
Fugitive. All right. We're gonna go ahead and I will reduce it, Ms. Martin. It'll be a $5,000 split bond, $2,500 cash surety, $2,500 PR. He may reside, I mean, if he lives in La Union, if he's able to bond out, he'll have a curfew, no contact with the complainants, commit no new offenses, use no illegal drug or alcohol, subject to testing. That'll be it.
Judge, I wanted to say, there was a misprint at La Union. It's Anthony, New Mexico.
I knew it was in New Mexico, and that is my.
Okay. So I don't have a problem with him if that's where his residence is. I don't have a problem with him as long as he's reporting. I'm sorry, reporting once a month to PR bond. Okay.
Thank you, Judge.
All righty. Thank you, Ms. Martin. Do we have any more, Chuy?
No, Judge, that's the last individual.
Okay, I feel bad about Ms. Lerma. I thought we were going to run quite a bit long.